Continue the recording. Excellent. So thank you very much for joining us for the cyber workshop. Today we have with us two speakers, Professor Duncan Holis and Dr. Eneken Tikk. Professor Holis is a professor of law at Temple Law University, and in the past, he worked in the office of the legal advisor in the US Department of State and has been involved in some of the most famous cases before the ICJ, including the Avena case and the oil platforms case. And we are delighted to have him with us alongside his co-author, Dr. Eneken Tikk. Eneken is joining us from the Erik Castrén Institute at the University of Helsinki, and she's also the lead of strategy and power studies in the Cyber Policy Institute in Finland. In the past, she was also an advisor to the Estonian expert group in the GGE process and the lecturer of international law, of international cybersecurity law and policy at the University of Tartu in Estonia. Today, we will discuss peaceful settlement and international law in the cyber context. I will yield the floor to our two speakers, and later on, we will open it for discussion. So thank you very much, Duncan and Eneken. Thank you.
Well, thank you, Tal, for that introduction. I'm gonna share my screen, and I'm gonna take the lion's share of the presentation time, mostly because the invitation came to me directly and I accepted and didn't tell Eneken that I had accepted, and so as a result, I feel it's on me to present our paper. Although I'll give her a right of rebuttal when I'm done. Let me also begin with a caveat. So we are both international lawyers who think about cyber and cybersecurity extensively, if not the majority of our time and effort. And we began that project with that approach in mind. But both as the project evolved and the feedback we've gotten through some blind peer reviews and the like has been that this ends up being much more a paper and a project about peaceful settlement at large, and that we should focus on that. And then as a second project, turn back into the cyber context and see what lessons we can draw from it. So, but apropos of this group, let me get us started in a cyber realm before we go directly into the peaceful settlement idea itself. For an audience such as this, I don't think I need to spend much time on the ubiquity of disputes in international relations on cyber issues, whether it's the attribution and responsibility, the naming and shaming out there, and who's doing what, whether it's the debates about what the existing relevant rules are in the cyber context, when we have agreement on a relevant rule like non-intervention, what it means in a digital environment, to say nothing of what remedies exist, and there are even larger disputes over what the appropriate vehicles are for regulating the space. That is, extending general rules to the cyber context, or perhaps pursuing a new treaty or tailor-made regulation. I think what's interesting and what kind of among the things that spawned us in this project was that if you survey the landscape these days, and what are the solutions to the current set of disputes, you keep coming across peaceful settlement of disputes as something that, one of the few things states seem to be able to agree on. So, I think there was a lot to be praised in both the open-ended working group's consensus report and the group of governmental experts consensus reports from this past spring and summer. The fact that they got them at all was great, but they, I think it would not be too radical for me to say they didn't really move the needle when it came to international law in cyberspace. And in fact, the one thing they both seemed to agree on was, but we can agree that peaceful settlement of disputes is a concrete obligation that states have to employ as they approach this domain. That's about all they agreed on. Everything else was kind of in that voluntary norms space, and a curious reference to IHL in the the GGE report, but they didn't really do that much. And so that, to us at least, begged the question of, well, is peaceful settlement of disputes, how does it operate in the space, and what might it tell us about regulating, global cybersecurity or international relations in cyberspace? It's worth here me just flagging. Most of you who are international lawyers will know this, but when we talk about peaceful settlement of disputes, we're primarily, although not exclusively, discussing Article 2.3 of the Charter and its overall obligation, and then the kind of the menu of modalities that we see in Article 33. That can be employed when a dispute endangers international peace and security. What I think was curious to us as we then, delved into this is that, we have states in the GGE, in the OAWG saying peaceful settlement, peaceful settlement, peaceful settlement. But if you actually step back and look at the scholarship, there's some real questions of is it up to the task at hand? Conceptually, I think, states and scholars have done very little to theorize peaceful settlement. And when they do, they tend to treat it as derivative or subsidiary to Article 2.4, to the prohibition on the use of force. Doctrinally, and I should give Eneken credit for this, so she may want to elaborate when I'm done. It's surprising how little agreement there is on what the obligation of peaceful settlement entails. That is, as a general obligation, is it an obligation to not engage in forceful settlement? Is it an obligation to only settle disputes if they endanger international peace? Is it an obligation that is all about questions of jurisdiction and justiciability and what constitutes a dispute for purposes of international courts and tribunals and compliance processes? Or is it an obligation to settle all disputes that states face? And that, I think, leads to a practical challenge, which is if we don't know what the doctrine is, it's hard to actually assess what to assess compliance or the strength of the obligation. And it leads folks like Pacem to dismiss it as weak and imperfect, while others, frankly, often ignore it. And you have major treatises and texts on international law that give the topic fairly limited attention, again, as a general obligation. This is not to say that we don't see a fair amount of attention to particular modalities of peaceful settlement. So obviously there's a rich literature on international courts and tribunals and compliance and effectiveness in that context. If Yuval was joining, I'd flag his work on that in particular. But we don't see it with respect to, the Article 2.3 obligation, for example. So the aim of our project as it evolved was, as I said at the outset, we ended up stepping back from the cyber context and said, let's demarginalize and reconceptualize the concept of peaceful settlement and kind of, resituate it in the international legal order as more fundamental. So we begin conceptually. We're going to I'll explain. We de-link peaceful settlement from the use of force as a historical matter. Doctrinally, we want to unsettle attempts to define disputes entirely in judicialized terms. Any standard scholarly treatments tend to do so. We also want to expand who the obligation applies to. It is obviously an obligation for disputing states, but it's not, as I'll discuss, limited to disputing states. And I think one of our biggest contributions is to say, as between those four readings of the obligation, that rather than seeing them as in competition and you have to make a decision to prioritize one, we think there's actually a broader standard of conduct that looms behind all four, and that they actually are different manifestations of that same standard applied to different actors in different contexts. And so you can have a holistic reading, if you will, of the obligation. And then practically, I think doing so, having that holistic reading, opens up avenues for kind of figuring out what compliance and conformity with the obligation looks like in terms of things that are prohibited, things that are required, and things that are permitted. And that, I think, allows an even broader conversation about what peaceful settlement purports to do, right? What are the functions? Something that we found surprisingly very little attention has been given to. And I think maybe that's just because the title presupposes that we know what peaceful settlement of disputes is for. But actually, if you break it up, there's kind of components of it. There's the dispute settlement, the private function of, as between disputing parties, figuring out how inter se they will resolve their disputes. But there's also public functions in terms of protecting international peace and security, ensuring justice, and constituting international law, right? Like peaceful settlement of disputes is often a significant source for us of how the law is either iterated in the exchanges in the dispute, whether it's in the negotiations or the like, or in the outcomes in terms of decisions of arbitrators or international courts and the like. So that's kind of the overview of the project as a whole. So let me just kind of quickly walk through. And we start the paper off, and I think it's worth just a recollection. We start the paper off with the story of Greytown, which is a 19th century story where Greytown in what is now Nicaragua, their citizens had seized the property of a U.S. company and assaulted a U.S. minister to Nicaragua. So the United States Navy was sent to Greytown to seek, reparations for these injuries. The town council not coming forward with such payments, people were instructed to leave the town, where the naval captain ordered the bombardment of the town and then setting it afire. And at the time, the U.S. President Pierce kind of noted that this, was not all that exceptional, that this, was part of a long history of states using force as a means of settlement, even almost kind of as like a legal trial, with the victor actually, winning the argument, so to speak. And I think whether it's in terms of war manifestos or the like, for centuries, this was an international law afforded states the option to pursue the forceful settlement of disputes. And so for a crowd like this, of course, most of us think about international law histories with the story of how that, era of forceful dispute settlement came to an end. We can invoke the Calvo Clause or the Drago-Porter Convention, where we start to see this idea that taking the use of force off the table when it involves, trying to, settle or recover, contractual debts, right? Failure to pay should not be the basis for force. And then that expands, obviously, in the Covenant of League of Nations to make restrictions on war and more explicit. The Kellogg-Briand Pact, most, infamously perhaps, outlaws or prohibits war itself. That doesn't preclude World War II, of course. And it leads us to the UN Charter and its Article 2.4 prohibition that is now, I think, somewhat widely regarded as a jus cogens obligation, a peremptory obligation of international law. I think what our project, did was to kind of say, well, this is all a really interesting story, but it is not the case, as a number of scholars have insisted, that then Article 2.4 and Article 2.3 are historically linked, and that the beginning of peaceful settlement is when we end forceful settlement, right? That like, in fact, peaceful settlement, it has a longer history, and it wasn't until we prohibited the use of force that we suddenly had obligations of peaceful settlement. You can go all the way back, to the Peace of Westphalia, if not before, to find obligations of peaceful settlement. Article 123 of the Treaty of Munster, for example, quite famously, required states to work on peaceful settlement for a period of up to 3 years, a cooling off period where they should try to settle the dispute peacefully before they could, engage in forceful dispute settlement. And so I think what we wanted in this article, in this project, if you read the paper, is to kind of situate the UN Charter and its obligations as a midpoint in the narrative, not the beginning, and also a midpoint in the sense that we've seen subsequent global efforts to elaborate the obligation of peaceful settlement as a general matter. You can look here at these kind of various UN resolutions, the 1970 Friendly Relations Declaration and the Manila Declaration being key vehicles to kind of take what's in Article 2.3, what's in Article 33, and elaborate on it in key ways. Of course, it's also the case that peaceful settlement is manifested as an obligation elsewhere. Look to the regional constitutive instruments of the OAS, the African Union, et cetera, and even the Arab Pact, and one consistently finds an obligation for the states parties to settle their disputes peacefully, and oftentimes with some mechanisms for doing so in a regional context. I think one of the other things it's worth not losing sight of is the fact that we now have dozens, hundreds of treaties, dozens of treaty regimes where peaceful settlement has been allocated ex ante, where there's a pre-commitment to peaceful settlement when and if disputes arise within that particular context. And I think obviously that's welcome for these regimes, whether it's trade, environment, or what have you. But we see it also as a manifestation of at least state practice with respect to the obligation of peaceful settlement. And, you know, in some ways, one might also ask if it's at least in some ways opinio juris with respect to the obligation generally. So I think as we kind of looked at it, we wanted to kind of establish peaceful settlement as an obligation in its own right, that it has this autonomy and kind of to dispense with the scholars who've said, oh, you can't have an obligation of peaceful settlement without the obligation prohibiting the use of force, and to kind of, you know, delink them as it were. In terms of the doctrine, right, having worked on the concept a little bit, we think there are three core issues, or at least three core issues that we wanted to address, which is, you know, what's a dispute, right? Because the obligation applies when you see a dispute. Who's bound by the obligation, and what does the obligation of peaceful settlement actually kind of entail? And I think in terms of the when, you know, we're looking at this idea of a dispute, but here we really wanted to emphasize that although there's all this Permanent Court of International Justice doctrine, you know, describing a dispute, and ICJ jurisprudence and others, that it's a mistake, probably a category mistake, to treat those definitions as coextensive with the definition under the general obligation, right? Because when a court describes what a dispute is, it's doing so for purposes of its jurisdiction or its justiciability. But we don't believe that the peaceful settlement obligation is limited to international legal disputes that are capable of judicial resolution, that the disputes can encompass a much broader array of tensions among nation states. And so we wanted to kind of step back and say, well, the obligation can arise, of course, in disputes that are capable of judicial resolution, but not they're limited to. And so, you know, we think it's important to kind of disaggregate, you know, when you might be able to judicialize a dispute and treat it as subject to, you know, international courts and tribunals or other legal means of resolution, and when there might be, we might want to think about it outside that context. In terms of the international courts approach, I'd flag, you know, we've often again relied on the and I don't know why it's PCIJ, of course, first typo in this. But in terms of the ICJ criteria, you know, we've seen the ICJ say that, you know, if a dispute is going to exist from, you know, a third party can identify a dispute even if one of the participants in the dispute won't admit it as such. Although there does seem in the recent cases, the Marshall Islands case in particular, a sense that that you can't invent a dispute of which the other party is unaware, right? There, the United Kingdom, the ICJ said, had no way of knowing that the Marshall Islands had a dispute with the United Kingdom and the United States in particular on their lack of non-proliferation efforts to you know, get rid of nuclear weapons. We've seen also the idea that disputes must be both specific and intense. You know, hypothetical problems are not yet disputes. You know, they have to actually kind of mature and be concrete, and they have to kind of have a certain level of intensity. Policy differences among nation states are not necessarily disputes. You need, if not diametric opposition, at least significant divergence of views in more concrete ways to create a dispute. But beyond just justiciable disputes, I think that, you know, we could look at, you know, a broader sense of thresholds in terms of differences of facts and differences on politics or differences on, humanitarian values or the like, independent of differences on the law. And we similarly could, again, group these sorts of things by substance in terms of what kinds of disputes are there, you know, in addition to quote unquote legal disputes that we would say the obligation applies to, because we don't see anything in the charter or its history to suggest that the effort was to limit to legal disputes, as it were. I would say that there's also a number of folks, including Shaw and Brown and the like, who've kind of said, the project of trying to define what a dispute is maybe a fool's errand, and that we should just leave it up to the intersubjective assessments of those engaged to tell us when they think they have a dispute, or the like. And I want to make sure that we acknowledge that's an alternative approach here, which is to let the politics dictate the disputes, and not that disputes dictate the politics. I think in terms of who does the peaceful settlement obligation cover, our effort was to obviously say it covers the disputing states. Both Article 2, 3, and 33 speak in terms of those that are involved in the dispute have to do with their obligation to peacefully settle. But it's worth noting, things like Article 52 of the Charter also seem to suggest an obligation on other states to participate or facilitate peaceful settlement. And so, as we see the obligation at its broadest, it would be, we think, a mistake to say it's only an obligation for the disputing states, and in some ways it may be an obligation on other states to work to resolve and participate in the resolution of disputes, particularly those that are, in a particular region, or those that involve endangering international peace and security. And of course, if we think about it in terms of international organizations or international institutions, obviously they can have disputes of their own that they need to work on settling. But if you look at their constitutive instruments, it's also clear that the mandates, and indeed one might say the obligations of certain IOs, are to participate in the peaceful settlement of disputes. Most obviously, the UN Security Council under Chapter 6. But also the UN General Assembly has assumed certain rights and responsibilities, particularly in the absence of Security Council action. And the Secretary General has a long history of participating with the consent of disputing states in various mediating and conciliation roles, including like the Rainbow Warrior case, which we highlight. So we don't do as much with these other obligations in the piece, but we want to open it up. And we might, in the Q&A, think about what this would tell us in terms of how do we construct peaceful settlement in the cyber context. I think returning to this idea that there are 4 distinct readings out there, do you think peaceful settlement is only, that you have no obligation to settle, you just have an obligation not to use force when you're settling? Or do you have an obligation to only settle if international peace and security is endangered? Or is this all about what thresholds there are for taking things to a court or a tribunal? But there's folks like Christian Tomschat who have argued, actually, it's an obligation that is on all the time. It's a consistent obligation that anytime you have a dispute, Article 2, 3 is not written to suggest that there's an on-off switch, but that anytime there's a dispute, the obligation is an absolute one to work on settling it. And as we kind of tried to reconcile these readings, we think rather than prioritizing one, here I'd note, for example, the Tallinn Manual does prioritize one. It says the only obligation there is to settle disputes peacefully if they endanger international peace and security, kind of rejecting that kind of absolute view, as it were. But we think actually there's a way to treat them all as coextensive. You can always not use force, just as you can always engage judicialized processes when you're either committed to or in your discretion you think they'd be useful. And in terms of the peace-centric and absolute reading, we think both involve an obligation of effort, but it is only when a dispute endangers international peace and security that the obligation manifests also as one of result. That states are required to settle their disputes that endanger international peace and security, or otherwise refer them to the Security Council. Of course, that opens up the question of, well, if there's this holistic obligation that is going to manifest differently in different contexts, how do we decide what compliance is, right? How do we decide what a violation of the general obligation looks like? And here we flag, I think, that there are some pretty kind of daunting challenges. One is accessibility. Right? Examples of people saying the general obligation is being violated are difficult to identify. I think that may be a little bit a function of, we only get to see a sliver of disputes and dispute settlements. So many of them are actually, being taken place not on the public stage, but in diplomatic behind the scenes contexts. I think the history of treating peaceful settlement as kind of a junior cousin to Article 2.4 has meant that there's been little effort to try and measure compliance. And I think, frankly, the nature of the obligation also complicates compliance, because in most cases, you're in performing the obligation, you're not just going to be trying to settle the dispute, but you're also going to be trying to agree on how to settle the dispute. And if you're trying to agree on how to settle the dispute, it may behoove you not to flag the failure to actually settle the dispute, because that might just escalate or destabilize your ability to get to agreement on a process for peaceful settlement, as it were. And I think that lack of agreement on what the obligation entails adds some further complexity, because is it clear we're just looking for uses of force as violations of the obligation, or are we looking for a broader range of conduct? We do think, though, that you can synthesize the obligations manifestations into a set of prohibitions, requirements, and permissions, keeping in mind that the obligation is always one of effort, and that may manifest into an obligation of result in certain cases. As I said, with respect to the peace-centric view. Here's a quick flag. In the interest of time, I don't want to get too caught up in going through each of these. The paper does so. You can look at the paper, but we try and identify like what are the prohibitions in each of these different manifestations. Steve Ratner has a great article on the duty of non-aggravation in the recent Journal of the European Journal of International Law, that we think helps inform below the use of force threshold, the sorts of things states should not do in their disputes. In the judicialized context, you should honor your pre-commitment to dispute settlement or adhere to its results. But broader obligations are not to engage in bad faith, not to delay dispute settlements, for pernicious reasons and the like. At the same time, we view it obviously as a set of more positive obligations to operate in good faith, to do so persistently. You don't get to say, we've worked on settling the dispute for a year, it hasn't worked out, we're done. No, it's a continuing obligation that the ICJ at least has said has to be meaningful. And at the same time, I think it's a mistake to think about compliance in this context only as prohibitions and requirements. And I think Eneken joins me in this. And so we tried to identify what's conforming behavior, like what is the sorts of behavior that is consistent with the obligation, and what does that look like, and how does that inform our understanding? Quickly, I'd say we were cognizant, as I think all international lawyers should be, of stepping back and thinking about peaceful settlement, not just as we have an obligation, is it honored by states, or what do breaches look like, but like what's the point, right? Like why do we have this obligation? To what ends does it serve? So then we can ask about efficacy, and think about how well do different modalities of peaceful settlement, mediation, conciliation, negotiation, arbitration, and the like, when and how well do they serve the functions? And obviously you could do that inductively. We did not. This is not an empirical project, but one could, as has been done in particular dispute settlement fora like the ICJ or the like, you could engage in cataloging state practice and asking, how well the obligation is being honored and what it's serving. But, we wanted to at least put forward a more functional deductive model, where we think about dispute settlement, peaceful settlement as sometimes serving that private, how do the two parties have an interest in having their dispute settled so they can move forward, but also the communal interest in peace and security and not having third-party states fighting with each other. And Article 2.3 is framed on purpose in terms of also facilitating, or at least not being inconsistent with justice. You don't necessarily want appeasement settlements in the face of aggression, and that's not consistent with the obligation. And then, as I alluded at the outset, the fact that we see in peaceful settlement an iterative process of communication over time, a transnational legal process, if you will, that helps us construct or at least elaborate legal obligations. And for each of these, we offer, kind of a very tentative set of what sort of conditions you might want for peaceful settlement modalities, right? If you're only focused on how do we get two parties to settle their disputes, it's really important that both parties be on board and engaged, and that they meaningfully, intersubjectively agree that they're settling their dispute. And that requires some flexibility. It may, may be less concerned about general rules of general application and more how the dispute manifests for the particular disputants. Whereas if we're worried about international peace and security, then we want dispute settlement modalities that are much more coercive and restrictive, that achieve that outcome, even if it's at the expense of the subjective views of one of the disputants or their, voluntary engagement. Justice is a whole, maybe I'll bracket justice for now, because, it's a consistent through line for all legal thought, but obviously a super complex one that has multiple meanings to multiple audiences. But if, you're focused on the construction, you want the peaceful settlement to have a role in lawmaking, then publicity, transparency, and reasoning are all important aspects that may lead you to one modality over another. Obviously, you can have a peaceful settlement that is may affect multiple functions. And one of the questions that we at least raise and touch on, but don't fully resolved, is is there a priority list among these three? Is justice more important than peace, or peace more important than justice? And how do you reconcile when there might be competing functions that peaceful settlement might serve? Which should take priority in terms of assigning what compliance looks like, and also assessing effectiveness. So I'll tentatively just kind of wrap up here, and again, for a cyber group, take us back to open the door now to cyber. Like the goal was conceptually, doctrinally, practically to isolate and think about peaceful settlement, and kind of move beyond the what's the Article 2.4 threshold conversation, to think more like, what does peaceful settlement mean, as a vehicle to then saying to states, okay, you've all said you value peaceful settlement in the cyber context, whether you're at the OEWG, the GGE, or these national statements that are now coming out once a week, it seems, giving it, is it just lip service to peaceful settlement, or how are you going to put proof to practice? And it's our hope that our project will give states kind of more serious arrows in the quiver, or more serious ways to think about the content and functions of peaceful settlement, that they can then build capability and demonstrate political will to pursue it, so that it's not always just about disputing and things like countermeasures, but also looking for opportunities to settle, as it were. So I was told 30 minutes. I think I've hit it okay. But I hope you'll indulge me before I turn it back to you, Tal, to give Eneken that promised right of rebuttal to either correct what I've said about the project, or Eneken, if you have any elaborations for a cyber group, I guess those would be welcome, although I'm happy to put my inputs as well.
Well, thank you. May I share my screen? I was sort of fleshing up some slides just to react to Duncan, or emphasize some points over, if that's okay with you. So just
sure, you're a co-host now.
Thank you. Thanks for a quick follow-up. Going to my slides, putting them up. Yes, here. So I think it's more like adding emphasis, and I was just thinking about like how what we have done could be most relevant to those thinking about cyber issues. Like Duncan basically said it, that it is largely an invisible obligation, and not only because it's under researched, but because we rarely debate it, right? We don't really track the developments in this, but we very much are exposed to everything that seems like unfriendly, coercive, or even forceful, because that is the subject of this the debate. But yet, when we think about what is happening in the context of cyber operations, then the primary emphasis of the like-minded has been on this policy of consequences, collective attribution and sanctions, and then coming to this, like mainly debating the parameters of cyber operations, which should lead us to the question, are we really even trying to cool off something that we know, like for 500 years is a good idea to do? And do we know that attempts of settlement would be futile in all these cases? So meaning, how good are we as international lawyers in dismissing the obligation really before we even attempt to apply it? And Duncan said we work with these 4 readings. There are actually more if we go to nuance. But I think while these 4 readings and the fact that most of what we all do is peaceful settlement rather than resorting to unfriendly or coercive means, then while we are seeing a very strong principle, an old principle, we are really poor at reading the contemporary practice into the contemporary scope of the obligation. Because we know that it's not just the modalities in Article 33, which actually is most of what the House scholarship approaches this obligation and reading it. It is any modalities that we can think of, even like, let's say, track 2, track 1.5 negotiations, conventions, consultations, conferences. So there's a number of things that we maybe don't immediately see as how this obligation has developed. And we definitely have to take into account all these administrative and institutional means that by their definition are an attempt to steer the states to prevention rather than a response alone. And then, of course, the fact that in cyber, you could say that most of the cyber activities are conditioned by previously unresolved disputes. Now, there has been a critique that even between the like-minded views on international law and including this obligation, the readings are different. Well, in my last slide, or in the context of it, I would see this as a strength, not necessarily as a bad thing. Because if we now think, how do we fortify further our common presupposition that international law applies in cyberspace, then I think an essential skill for every international lawyer will be ability to see disputes, to frame these issues as disputes, whatever we then decide to do about them. Because, well, as Duncan said, that it's disputed whether hypothetical disputes are relevant. But when it comes to, well, do we have to really wait until they mature? Meaning, as lawyers, we can engage in the earliest stage possible if we only develop better the skill of seeing a smaller, like wider set of circumstances as dispute. Also, I think the skill to construe these matching modalities outside of parameters of only Article 33 and seeing the full spectrum of options. As I said, in cyber, we tend to see only responses. And finally, like just when I said that I don't think these differences between the like-minded are necessarily a bad thing, because here we can develop strategies where different like-minded states, well, think of, I don't know, Finland and the US, Sweden and Israel, for example. We come with very different skills and attitudes and experiences. And this is now, I would say, an opportunity still to be used in fortifying the like-minded current standing, that let's make use of the international law that we know and have. And in that light, why, coming back to this beginning of the presentation and also end my intervention, one reason, main reason why we decided to write about it is we realized that how we currently teach and study international law, peaceful settlement really doesn't have much of a role. So those brushes, and thank you for the opportunity.
Thank you very much, Duncan and Eneken, for this presentation. We will now open the floor for questions, comment, and discussion. If anyone has any questions or comments, please indicate in the chat or raise your hands. I will kick off the discussion with your permission. Relax. And so my cat is also always very eager to discuss academic articles. So my first question, you began with an historical evaluation or representation of the development of the rule. Now, I'm curious, what role do you see for this specific aspect of the discussion, the historical aspect? The question is, of course, arising given the fact that the history of international law, and specifically of the resolution of disputes, is tainted by colonialism, power struggles, and etc. And the question is, if we now want to take a rule which has been established based on some problematic experience, do we want to try and maybe propose a correction or a rectification to this situation? Because some of the tensions that existed back then, for example, power disparity, ability of one side to use force which the other side does not have, well, it rises again in the cyber context, right? You hear claims about monopoly of information and claims of on accessibility to information, and also disagreements on what constitutes actually a hostile cyber operation. So it seems like the history has actually a role in the current evaluation as well. And I'm curious, what is your take in this regard? In addition, there is also when we talk about peaceful resolution of disputes, well, of course, Article 33 is the rule, it's the principle which outlines the various manifestations of this rule and etc. But at the end of the day, usually dispute resolution will be based on a more specific instrument. If it's in the law of the sea, UNCLOS, if it's in investment law, then in investment treaty and etc. So I actually absolutely agree that there is a separate duty to resolve dispute peacefully. It's absolutely correct, but I'm curious, how should we balance in the discussion between the fact that we have one main general customary rule, we have a UN charter which proposes some possible avenues, but we also have many different specific treaties. Which one should prevail? And I guess that the answer will be also context-based, which is part of your solution. For example, if we're dealing with the law of the sea, then UNCLOS should get priority and etc. Now, another discussion in the cyber context is more generally how to apply different fields. Oh, the dog heard the cat. So there is a general question of how to apply international law in cyberspace, but the general question is different when we deal with different fields. So I think that that's the main challenge of this article. There are so many different relevant fields: telecommunications law, law of the sea, UN charter law, another specific instrument. It seems like a very hard task. So I think the work that you are conducting is highly important because it's also very highly difficult. So I'm curious to hear your thoughts, and I hope that my comments made sense somehow. It was with a panic in the back of my head that the cat will merge into the discussion. So thank you very much for the presentation also.
Thank you, Tal. I guess I'll go first, but on all of these, I'm going to let Eneken also, get last words. On the history point, I think a couple of things. One, I agree, or histories, I think is now the more accurate way to think about international law. There is the problem of colonialism, there's the problem of imperialism, there's the problem of the power disparities. But I think one thing that was interesting, particularly to me, in thinking about the histories, was how much the rise of peaceful settlement as a general obligation came from what we now call the global south, what we now call the less powerful, right? And in fact, and Eneken can elaborate on this, you see in particularly non-Anglo American tradition textbooks, it's in the mid-19th century that you start to see authors start to say there's an obligation of peaceful settlement far earlier than the UK, US do. And so I think in the one sense, that may also be a signal that that it is something that may have global appeal and has a potential to equal out these issues. It was certainly viewed as a way to equal out the problem of forceful settlement. But now, even in the context of peaceful settlement, I think you're absolutely right. We still have power disparities. Part of the stories of the GGEs, for example, in their histories was, the US, China, and Russia going off into a corner, coming to some agreement, and then taking it to the other 23 and saying, here you go, right? And so, this is how we're going to settle this. And I think that's a challenge. I think one of the things I specifically didn't talk about was the justice function of peaceful settlement. And I think to your first question, I think highlights the importance of keeping that as part of the strategic thinking as you're constructing or opting to pursue peaceful settlement, is keeping in mind that it must be not just a just outcome, but probably a just process. And that if justice and things like, respecting the sovereign equality of states, respecting human rights and values, if you're thinking about justice from at the human level as opposed to the international level, keeping those foregrounded in peaceful settlement is going to lead to different dispute settlement modalities. It may lead away from negotiation in certain contexts and more towards either conciliation or third-party involvement to kind of level the playing field than it would otherwise. And so I think that it's a great question, and it needs to be absolutely included. I think to your question about the complexity of the international legal landscape, I mean, on the one hand, I'd say, well, this is a problem. This is not a cyber problem. This is a international law in 2021 problem. Is that any issue that we have may have a trade component, may have a climate component, may have a human rights component, has an IHL, et cetera, et cetera. And so there's that fragmentation and how of norms and of just of jurisdiction and who gets to responsibility for regulating or resolving it, as it were. I do think. Nonetheless, what our project was I don't think we contest any of that. I don't think we contest that if the parties want to use, think it's primarily a law of the sea problem and they want to use ITLOS, they can. And if they think it's primarily a human rights problem and human rights settlement regimes are triggered, that's entirely appropriate. But it's, in some ways it's in the absence of that, or it's in the phase of disagreement, is to keep the eye on the background overarching obligation that, even if you might be adding to your dispute a dispute about where to resolve that dispute, which is the right regime, that you still have the underlying dispute and an obligation to resolve it. I think was one of the things we were trying, to contribute in this. But that's my take. I don't know, Eneken, feel free if you have further thoughts.
So on the history point, very briefly, I think that is now precisely where we see these 90% of countries, or most of the countries, doing it most of the time. And unfortunately, many of our countries are actually in the 10% or the minority, which highlights that it's not just a history in the past, it's a current history that we need to be mindful of. And for what we are criticized in cyberspace, in our activities, we can make up by at least demonstrating our ability to appreciate the obligation, right? So meaning that goes to, if we think it's futile, we need to make that point before just resorting to where we normally tend to go. On this variety of instruments and regimes, like one, I think I agree with Duncan that this is the challenge of international, not even law, but for international lawyers in the 21st century, because it become a rather different field from what it used to be, where you could afford to be a generalist without going to all the seven corners, right? So I think one of the skills we need to really develop as international lawyers is our ability to see a principle, so to see the trees from the forest, right? And I'd say all these myriad of specialized dispute settlement mechanism only prove the strength of the general obligation on which they are based on and then derive from.
Yeah, and if I could just, come in on the top of that. I mean, particularly in the cyber context, where we are back at that general rules level, right? Where, you hear constantly, we don't have a specific cyber regime, right? And there are difficulties in extending some of the other regimes into the cyber context. And we're in this non-intervention, sovereignty, like these generalist debates. I do think that the general obligation has some value because it meets the general at the general. And as we move forward and hopefully elaborate a more developed and mature regime for cyber disputes, we can bring in those other more specific mechanisms.
Thank you very much for this very elaborated reply. We have more questions from first Dr. Yali Shoshevsky. He's a research associate in our center and also our professor at Haifa University. Please, Yali.
Thanks, Duncan and Eneken, for a really interesting presentation. I have two questions. The first is, what's unique about cyber in the sense that you frame the project as a project about cyber, but usually, right, projects about cyber says something unique about cyber. We should reinterpret IHL or, I don't know, human rights to apply to cyber. But here it seems that the problems that you're discussing are general problems of the issue of peaceful settlement. And in this regard, I wonder what's unique about cyber and whether your project is not about reviving this notion of or the importance of peaceful settlements in general, rather than a project about cyber. And moving to the general project, it seems to me that you suggest that one of the main problems is attention, right? We didn't really care about it. We focused about the use of force or other norms. And I wonder whether it wasn't intentional. It's not that but it was a chance that nobody really focused on peaceful settlements, but in fact it was a conscious decision to have this obligation as something that is more political or diplomatic rather than a legal obligation, to have it something open-ended that we do all the time, but we don't really frame it in legal terms, and focus when it comes to actual binding legal obligations on actual uses of force. And in this regard, if this is the case, that it was actually a conscious decision, then maybe this clarification project or shifting the attention won't have a real effect in the world, because those actors that consciously wanted to disregard the legal obligation about peaceful settlements will not change their position regarding the way, the place of this obligation in international law.
Great questions. Thank you. The first question, my answer to you is straightforward, is that you're absolutely right. The paper does not do enough with the cyber specifics. And so, Eneken and I are actually working on a revised draft, or we have kind of a revised draft where the cyber introduction, frankly, is being removed. And we're just turning it, I think, into a broader public international law piece with some cyber stories kind of sprinkled throughout, but it's much, your reaction is not the first time we've heard. I started the paper and thought this is going to be an interesting paper about cyber, and then we don't deliver on that. And so that's well taken. I will take your invitation, though. We didn't do it in the project, so this is just kind of tentative on my thought. I think some of the things about cyber disputes that are going to need to think about cyber dispute settlement is obviously the involvement of code, right? And you could refer, we before we got started, we were, I think we were going down the, law of the horse and all that, versus, do we need something tailor-made here? And, the idea that code regulates cyberspace in a way that, we don't have with many other contexts, because we can't rewrite the laws of nature and just have to accommodate them as part of international humanitarian law in terms of, how, physics operates and causes physical harm and or prevents that. In cyber, dispute settlement can involve agreement, but it also can involve just re-engineering and thinking about what that, dispute settlement by code is something I think that's worth thinking about. And then I think speed is something. Yeah, dispute settlement by code. I like it. And then the speed, I think that and this is not limited to cyber, but the speed at which cyber activities occur and therefore which disputes may arise is, I think, challenging for us lawyers, right? Like, you think about like how long it took us to agree to ban slavery and then how long it took us to agree to ban the use of force, and like, we're not really good at acting in months, let alone weeks, days, or milliseconds. And so I think is something to think about. In terms of the attention point, I think that there is something to that I think certain states are quite happy with a status quo where the focus is on a very rough use of force threshold and some lines there, but they can come right up to the bottom of that line and nobody's kind of calling them to account in terms of, well, what about the other side? Instead of always trying to vindicate your interests, what about reconciling? What about looking for compromise? I guess my response on that is, you said, oh, it's a decision to ignore or a decision to de-emphasize. A decision by who, right? I think it's one thing to say, actually, the entire international community of states have all decided to de-emphasize it. I suspect, again, more of an empirical question, but for our purposes, let's make it kind of an assumption that it is not the entire international community that has taken that balance, right? It's a few more powerful actors. And so another point of our project may be, in some ways, to wave a flag to draw attention to less resourced or less powerful actors in the international community to elevate it in a way that then they can maybe collectively or in aggregation come together and call to account the cyber powers and say, yeah, you might be happy with this status quo, but actually it's not all that great for the rest of us. And so let's think about what your legal obligation looks like and how you perform it. But again, I've given Eneken more time to think, so maybe she's got additional thoughts that will critique my own.
Well, I just need to come out of the closet in this like bunch as well, because Duncan knows I'm on a mission since very many years now, having been like directly responsible for starting the Tallinn Manual project. I always wondered how the heck it came out the way it did, because I never expected that would be the answer on how international law applies in cyberspace, yet it has become the answer. Now coming to this cyber in the article or in the thinking question, I think the way to change the discourse or like balance the discourse needs to happen by taking distance first and then putting things back to cyber bubble, because within the cyber bubble it's almost impossible. So if you write a cyber article, you will not get traction much, but if you gather this bigger review or a community that wants to put some of these concepts into cyber perspective, I think that's more meaningful. So my current project, and then Duncan became the first victim of it, is to actually get reviewed the 10 principles of the Helsinki Final Act, and then in some years from now, in a bigger event, to translate those back to the cyber context. And obviously this is something that the Nordic countries are keen to support. And then just on this speed and attention point thing, I think because things are happening fast, and because there is not enough attention to the subject, then again, as legal advisors, we almost need to be algorithmic in seeing the full spectrum of international law vis-a-vis cyber operations, not just the loudest voices and responding to them.
Thank you very much. So our next question will be by Dr. Tibor Molin. which was a visitor in our cyber center and now teaches in the Catholic University of Lyon. Bienvenue à la soirée, Thibaut.
Yeah, thank you. It was great to be at the Federman Cybersecurity Center. I had a great time there. Well, thank you, Duncan and Eneken, for the great presentation. I really appreciated it. I would probably have a more general question about the cyber threats. I mean, most states would agree that use of force is prohibited in cyberspace. Most states would probably agree that there must be a peaceful settlement of disputes. But what happens when the substantial rules, so the ones which should apply to the dispute at stake, are ill-defined, as it is the case in cyberspace, I guess? And what is the potential for courts to solve these problems and these questions? Thank you.
I keep going first. Eneken, you want this one? I have ideas, but I don't know. I don't want to always be going first.
Please go first. I'm just formulating my thoughts.
Okay, I'll go first. I think it's a great question, Thibaut, and it takes me back to the functional analysis I was thinking about. And it really, for dispute settlement purposes, it really depends on what function we're assigning it, right? Because I think, all right, so if the law is disputed, but our primary concern is just providing that the obligation is focused on the parties themselves and not the broader community, and that they need to get to settlement, then maybe the debates about the law are not all that relevant, right? As long as that the parties have discretion to come up with their own solution, and they don't need the clarity in the law, right? They can what are the interests and values at stake? They can reach a settlement, and we move on. I think you're right. It becomes much more problematic if we start to take an international peace and security frame, because it adds another layer to the dispute, because then we have a dispute, and then we have a dispute about the relevant standards for resolving that dispute, and that complicates it. And that may then lend itself to ideas of I mean, for all our effort to say don't think about peaceful settlement entirely in judicialized terms, there is a time and a place for having binding third-party dispute settlement. And in some ways, cyberspace right now does cry out for some, international tribunal to at least give us something on which to build that we can point to in the way that, say, in the use of force context, we point to Nicaragua, even if at the time the U.S. wanted us never to point to Nicaragua. It's remarkable how much the U.S. government now relies on the Nicaragua decision as an articulation on, both, jus ad bellum, jus in bello matters and the like. And so I think it's a great question, but I guess my thing is that we don't have to wait, right? Like, we don't have to sequence this of let's figure out what the rules are first, and then we can apply peaceful settlement to them. I think the problem, of course, is if we wait, we may never get there. I think, we are increasingly looking at a world where we're going to have silos, competing camps on, the different views of international law, even among the like-minded, right? You can catalog the GGE annex and start to look through, and you can see on everything from due diligence to sovereignty, such a spectrum of views about whether the law is relevant, and if it is, what it means. That I think that has to be part of the accounting when you're doing peaceful settlement of disputes, but I don't think it precludes it, if that makes any sense.
Thanks, Duncan, for giving me the time to think. So I would just add to it, well, one thing that I think all these states that are involved in cyber operations, and they are less than we actually are instructed to think that do that. They are all pretty occupied with staying out of legal trouble, right? Meaning that because as soon as the ICJ, or for that matter any legal authority, were to assess the current policies and the current activities in cyberspace, I think they would have a problem with that as lawyers. So that goes to this. First of all, through this, we clarify the rules already, right? Because there have been operations based on these international responses and temperature. States have at least it seemed to have taken a step back from, let's say, some types of attacks against critical infrastructure. So they don't want to be painted as doing those operations. And while that is ongoing, I think it is extremely dangerous for us, the like-minded, to wait until the other side will come and accuse us of not of there not being the law of international peaceful settlement, and then drag us into the discussions where all we have to do is to justify how we still are clarifying the rules of operation. So all that, again, it to me speaks to the opportunity here to take this but more general and, yes, absolutely, like, obscure, because there is not enough discussion and attention to them, rules to the table before we are dragged to the public court court of public opinion for what we seem to be doing most.
Thank you.
Brilliant. Thank you very much. So let's make sure I didn't miss anyone, right? Okay. So on behalf of everyone, I would like to thank from the bottom of our hearts Duncan and Eneken for joining us in different hours from different sides of the globe. It has been very interesting and insightful. And if you will have a newer version of the article or a different research, we are always happy to discuss it with you. Thank you very much. If you have any concluding thoughts, you have the privilege and right to do so.
No, I would just say, thank you. Thanks for the questions and the comments. As you all know from attending enough of these, there's sometimes the paper's underbaked and sometimes it's fully baked. And so, comments and questions are difficult, but we are right in the sweet spot of recasting this piece and thinking about the follow-on work of how we develop something that's more cyber specific. So a great set of questions and comments. And even if the project as a whole now has kind of moved a little outside the cyber context, I really appreciate the engagement. And we'll be happy to share a revised version, which I think we hope, we haven't discussed when we're posting it to SSRN yet, but like hopefully in the next month or so, we'll have something.
Yeah, which, be assured, will be stripped of all cyber, so we have to start it over again. Well, from my side too, thanks for including me in the literally last hour. I really appreciated the discussion, and I look forward to our discussion on the obligation to prevent or abstain from using of force and using force, and what that may entail in its contemporary coding. Anyway, thanks a lot.
Wonderful. Thank you very much, guys. And next week we will meet in person. We have a conference in person for the first time since the pandemic. So, désolé, Thibaut.
No worries. I will join at some point, hopefully.
Thank you. So have a lovely evening, everyone, or morning. And until next time.
All right. Thank you so much, Tal. Thank you.
Bye-bye.